SJC-11802, Commonwealth versus Piantedosi.
Mr. Sinsheimer, welcome back.
Thank you. May it please the court. My name is Robert Sinsheimer, and I represent the defendant, Mr. Piantedosi. This case is generically another one of these sad, tragic circumstances where the question of who did the homicide and how egregious it was never in doubt, and the issues are, to use the proverbial phrase, a battle of the experts with respect to the question of sanity. In the case of Commonwealth versus Mutina, many years ago, this court, dealing with the question of instructions, described the need to advise jurors that, quote, an insane killer, unquote, might be living in their midst someday, and that they had rights to understand that. It's a direct quote, insane killer. And I use it because I think that's a fair description of my client. And I understand that's a harsh phrase to be stating about a human being that I'm sworn to represent zealously. But in the tragic circumstances of a case such as this, I think it's a fair description. And then the question boils down more narrowly, is this particular insane killer legally insane? And that becomes problematic both as a question of law and a mixed question of fact and law, which is why we get into these proverbial battles of the experts. Now, I've raised two issues about the experts, and obviously, I suggest respectfully, they're sort of kissing cousins. One is about the defense expert, and one is about the prosecution's expert. But if you step back for a minute and consider something that really isn't in the brief, because at the level that we're discussing this, I think it's common knowledge to everybody, but we're talking about facts in issue and testimony in issue that's the product of Mass Rule of Criminal Procedure 14. And we have these very specific rules with respect to how and why interviews of experts, interviews by experts of a putative defendant who's willing to acknowledge the factual culpability and is placing an issue his own mental health, that apply so that by the time of trial, everybody knows with some at least rough parameters what the experts are going to say. Both sides have each other's reports. Both sides have access to prior testimony. These people don't come in cold. And everybody, from the point of view of the lawyers, has a very clear understanding of what the trial is going to look like. Nonetheless, as the law requires, everything is done on a question-by-question basis, as it must be. So when you get to Dr. Myers, who is put on first, even though he's the defense, first chronologically, I mean, even though he's the defense psychiatrist, he's asked relatively simple question, what did you learn from the defendant?
Do you want us to overrule DYS versus Juvenile and Commonwealth versus Hamey?
Do I want you to overrule it as such? I don't think so. And I think the reality is that In this
Aren't
case.
you asking us to do that?
No, I don't think so. I think juvenile is a general discussion of hearsay and general rules of hearsay. And obviously, it was problematic enough for the trial judge to go back and forth, that she herself was not sure that juvenile was crystal clear precedent. So I think what I'm really suggesting you to do is expand on juvenile in light of the more recent promulgations of Rule 14. I mean, look, respectfully, Your Honor, the whole point of the Rule 14, I think it's B for insanity, is so that the defendant can be interviewed. And then someone comes to court and asks him, what did he say during the interview, and it's cut out. So I suggest to you that's a glaring inconsistency in the law that you're in the position to if not outright fix, at least address.
Judge Kottmeyer, though, was, I thought, pretty clear in the sections furnished by the Commonwealth to say you can't get it on direct examination. Was there any attempt on redirect to offer this same testimony?
I don't think so. I mean, I think the record was made, and you caught me there in terms of, my memory of the transcript, but I don't think so. And I'll have to go back and take...
Yeah, I mean, she's trust me, she mentions a number of times you can't get it in on direct examination.
I wanted to get back, one of the reasons...
But I mean, so it goes to your, it's not that you can't get it in, you can't get it in on direct.
I don't think
You can get it in on redirect assuming after the other side challenges the opinion. But, so it's not an absolute bar, it's that you can't essentially get everything in on your direct if the other side is not arguably going to challenge the opinion. It's only when they challenge the opinion that it triggers, then the question is, what is the basis for the opinion? And there you get more leeway.
Well, Judge, that's exactly what... First of all, I essentially agree with the point that maybe it's admissible in some circumstances. Exactly why I began my discussion with talking about Rule 14 and the chronological order of events. Because frankly, if you ask me, this business about who's rebuttal and who is being the witness called on direct gets a little silly in these insanity cases.
Why would the Commonwealth have to call a witness when the defense isn't raised?
The defense was raised. And that's my point, Your Honor. There's a presumption of sanity. So after decisions like Juvenile and after decisions like Chappell, well, probably before Chappell, but certainly, the Commonwealth gets wise and decides, you know what, we're not going to put our expert on in our case in chief. We're going to save her for rebuttal because that gives us a little more room. And we'll try to tie up the defense as best we can, and then we'll come smoking in with our rebuttal witness, when the reality, everybody in the world knows that's not the way it's really going to happen, other than chronologically. It's a myth. It borders on gamesmanship, frankly, and totally legal. I'm not criticizing my brothers at the bar.
Aren't there often times when the Commonwealth doesn't even call a rebuttal witness?
I think it's very rare, at least in my personal experience, that if the defense has a
I've seen it a bunch of times.
Excuse me?
I've seen it a bunch of times.
Well, then the guy that you've seen it with, respectfully, wasn't as crazy as my client. Because I don't think there was anybody in this case that didn't understand from the minute we were going forward, from the minute the case began, that this was going to be the proverbial battle of experts. And the Commonwealth saved its expert, which I respect tactically, but I'm telling you, as the highest court of the state, it shouldn't have that kind of difference that when Judge Gantz was asking me, well, wouldn't it have been okay on redirect, kind of hinting that maybe trial counsel dropped the ball.
Because the order of who testifies is irrelevant to...
Exactly, I agree with you.
To DUIs versus juvenile and Hamey and whether or not it's admissible and direct or redirect.
But I think under juvenile, what it says is that, that anything that the expert relies upon, hearsay can be put into evidence with a limiting instruction to some extent. And the details of it may not. But a statement from a defendant in any other circumstance is going to be admissible. I mean, he's a party in the case, and he's a party who's chosen to acknowledge factual culpability of the most serious crime that anyone could ever commit in order to avail himself.
So if a defendant was interviewed by the police,
Yep.
and the defendant, take the insanity defense out of it, a defendant tells the police officers, I shot the guy, but he was coming after me with a butcher knife, and that's why I shot him. It's a statement of the defendant.
Yeah.
It's hearsay. It's
Yeah.
self-serving. Does it come in?
I think so. And I can tell you this, just as every case I've ever tried representing a defendant, I do everything I can to get his statement.
I know you do. I've seen it.
But the reality is,
But it
Judge,
shouldn't come in.
I'm not sure I agree with that. I mean, I think statements of witnesses who are parties are generally admissible. Because don't forget, that's a two-part statement. I did it. I think the Commonwealth would usually be happy with that, and then they would argue that the second part only was self-serving, but then you get it on the doctrine of verbal completeness. So the odds of that not coming in any given trial, assuming Your Honor's not on the bench, I think are...
Saved by that now.
But I think the reality is almost every case, a statement by the defendant barring suppression, Miranda and voluntariness issues, is going to come in one way or the other.
But I mean, I'm going to page 23 of the Commonwealth's brief, which cites the discussion. Defense counsel Casey, who I guess was with Mr. Calora. So you had Michael Calora in this case?
Excuse me?
You had Michael Calora was defense counsel?
Yeah, you have
So
good lawyers.
another quite capable
Very
defense
capable,
counsel.
indeed.
Our position, again, is that they're admissible not for the truth of what was said, but to prove that they were said to Dr. Myers, that they formed the basis of his opinion also, Judge Kottmeyer, but not on direct, which is a correct statement of the current law, that it can come in only if during the course of the cross-examination, the opinion is challenged, and then the expert gets the opportunity to defend the opinion, and there's more leeway given. So,
Well,
I don't. There are two separate issues. One is, does this come in? And the issue is, does it come in on direct? But I gather that it was never offered on redirect, so we're limited to the issue of does it come in on direct, and that's been our law since juvenile, and there are many, many cases which have said you get more leeway if they challenge the opinion on cross. But we're not going to let on direct all this hearsay come in so that you can get in your entire case through the expert when the other side may say, Your Honor, we don't challenge the opinion.
But the other thing is, Judge, I frankly don't recall if there was any redirect, and I apologize to the court for that. But what I do know is that there was a very specific offer of proof, and that's at transcript page 142 to 145, and I've got it in my hand. I don't want to waste my time reading it to you because you can find it. But, it's not like the defense counsel dropped the ball. The defense counsel did everything he could to make sure this record was as clear for you as it could be. And he goes, and there's nothing in this offer of proof, which runs for a good 2.5 pages, that is, I suggest, in any way prejudicial to the government, apart from the fact it's evidence they don't like and didn't want it.
Didn't a lot of that evidence come in elsewhere?
Yes and no. And I understand your question. In fact, it's a question I clearly anticipated, because one of the subtexts of this was whether or not Mr. Piantedosi was bipolar. And Miles says he was. So does the Middlesex jail. So did the Bridgewater, I'll call it prison, hospital, whatever you call it. So did Holy Family. So did a woman who was a therapist. But Allison Fife, who's never seen insanity, to the best of my knowledge, suggests that he was not bipolar. Now, with that as backdrop, getting to your question, and getting back to Rule 14, I think the jurors want to know that the psychiatrist that's being offered as an expert has actually spent time with the defendant. And Fife spent 5 hours.
But that's part of every direct examination.
Of course it is. But you don't think it's natural curiosity? Okay, you spent all this time with the guy. What did he say? And to me, it seems, again, when we're talking about a party in the case, the whole reason we have Rule 14 is so that these kinds of statements are I guess I can't say admissible because that's why we're arguing. So let me back up. The whole reason we have Rule 14 is so the experts can have access to these statements, and the whole reason we do direct examinations that lay the expert's foundation is so the jury can know what they're basing their opinion on. So if you step back now, and if you let me segue into the second issue, on the one hand, you have a guy, a doctor, who spent a lot of time with the defendant, but is not allowed to tell the jury what the defendant told him. And then you have another person who's allowed to say what drove the defendant without any basis whatsoever, in fact, and without any basis at all in the evidence. And just because she's a psychiatrist, she's supposed to be allowed to say what, quote, drives people. And I suggest to you that that's clear error, as I suggested, of course, in Goddard only a few months ago and didn't fare so well. But I do, therefore, that's why we filed the reply brief, because we think it's sufficiently distinguishable. And as you may recall, I can't remember if all of you were on the bench when I argued Goddard, but as you may recall...
I missed that opportunity.
Well, I'm not sure it was an opportunity, Your Honor, but Goddard, you know, in a somewhat analogous situation, there was somewhat analogous testimony that I thought was too Wild West, and I argued that. And as I understand Judge Lowy's decision, he doesn't really say that I'm wrong on the question of error. And I read it carefully. What he says is, you know, even if it's error, the facts of this case are so overwhelming, we don't have to give it the kind of weight that might be appropriate if the facts weren't so crystal clear. Now, of course, when I'm arguing Goddard, I can't agree with that. But now that it's precedent, of course I agree with that. Never mind he's my former client. This guy walked into a lady's place of work with a gun. He left the tape in the car saying exactly what he was going to do, and then God help us, he went ahead and did it.
Let me ask about the formulation of the opinion, because Dr. Myers testifies based upon the antidepressants, there was involuntary intoxication, and that's what caused him to commit the murder.
That
right?
was a factor in his opinion, but he also said he was bipolar, Your Honor. And that's
so involuntary intoxication plus the bipolar.
right, but there's a big difference between whether someone's bipolar and someone's not.
What I'm trying to get at is Dr. Myers issues an opinion that the combination between the involuntary intoxication and the bipolar disease causes him to commit the crime, correct?
I don't think he says he causes him to
Well,
commit
I'm
the-
trying to get from you, what did Myers say? What
But
are the magic...
he said that following the McCool standard, that combination of having this mental disease or defect combined with the known after effects of these kinds of drugs on this particular individual rendered him unable to appreciate the wrongfulness and the criminality of his act. He followed McCool right down
So we're talking about the difference between rendered him unable and then the use of the word drove.
Right.
By
And you know, you asked me a very similar question in Goddard because I'm clearly haven't convinced the court that it's more than semantic. In my mind, it's very, very more than semantic. No one on this earth can say what drove another person to do anything. The best you could come up with is after the fact, you can look at the conduct and based upon all of our own life experiences, draw some kinds of inferences as to why people acted. But certainly not a doctor. And if you were to ask, this is now extra record, I'll acknowledge that. If you were to ask a psychiatrist, can you predict what a person will do? Or they'll tell you that's the last thing they can do. And there's case law to that effect dealing with the duties of psychiatrists to report potential crimes in the future. These people don't know what drove someone to do something, especially after a few hours. But the juror's allowed to think that they do. And you realize, of course, again, getting back to my introduction, that's the only question in the case. You know, what drove this guy to such a horrific act that his lawyer could stand at the SJC and call him an insane killer openly without criticism? And my answer, of course, is that he was insane legally. But clearly there's something really wrong here. And to suggest, well, I know what was wrong. He was driven by anger and madness and all these stuff that any layperson can infer equally well is entirely unfair, especially in combination with the fact that his expert's opinion was denigrated. So As to all the remaining issues, I'd be happy to rest on the brief unless the court has additional questions.
All right, thank you.
Thank you very much.
Ms. Walsh, good morning.
Good morning, may it please the court. My name is Emily Walsh, and I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. With me is assistant district attorney Nicole Elaine, who is the trial prosecutor in this case. The defendant in this case received a fair trial, and none of the defendant's claims nor review of the record as a whole demonstrate a substantial likelihood of a miscarriage of justice. The defendant's first claim is that his expert was precluded from giving crucial testimony about the defendant's symptoms and medical history. There was no error. The judge correctly ruled that statements by the defendant are not admissible through the defendant's expert on direct examination.
And what happened on redirect?
On redirect, there was there was something pretty narrow that came in. On cross-examination, the Commonwealth raised an issue of medication compliance and how long the defendant had been taking the drugs. And on redirect, the attorney sought to introduce evidence that that the defendant had vomited to show that that's a side effect of the medication, and that there was a discussion about whether the door had been opened, and that did come in on redirect.
But I gather they did not seek to revisit what had happened during the course of the direct, even though the judge had expressly said not on direct.
I'm sorry, I'm not sure I understand.
The defense attorney did not attempt to try to put in again what he had tried to put in on direct examination on redirect, even though the judge had said you don't get it on direct.
The only statement of the defendant that came in on redirect was the statement that he had vomited as a result of the medication. But most of the things, as Justice Budd raised, most of the things that the defendant discussed came in. Dr. Myers testified extensively about the defendant's symptoms and medical history. The defendant claims in his brief that the jury was not permitted to hear that the defendant had symptoms which were, in Dr. Myers' opinion, consistent with bipolar disorder, but that's simply not true. During Dr. Myers' direct examination, he discussed the Leahy records and noted that the defendant had been struggling with mental health symptoms, particularly depression and anxiety, irritability, which could be a sign of bipolar, for a number of years. He discussed the Middlesex jail records and noted that prior episodes of mania are required to diagnose an individual with bipolar disorder, and noted that the Middlesex jail records document the defendant having manic symptoms such as mood instability, mood swings, racing thoughts, increased energy. And then again, after stating his opinion that the defendant does have bipolar disorder, he explains the basis of that opinion, noting depression with periods of mania. There are no further questions on that. The defendant also claims that the Commonwealth's expert's testimony gave rise to a substantial likelihood of a miscarriage of justice. First, in a discussion of the McCool standard, he challenges Dr. Fife's statement, "Sometimes I think of it as, but for the illness, would the crime have happened? You know, so," at which point the judge interrupted her and told the jury that she would provide the jury with instructions on the law. This fleeting statement discussing "sometimes I think of it as but for" is not an error, and certainly not an error giving rise to a substantial likelihood of a miscarriage of justice. The defendant also claims that Dr. Fife improperly offered an opinion as to the defendant's guilt when she stated that, "In my opinion, this individual, the defendant, was angry, he was upset, he had feelings of depression, sadness, mixed with anger, mixed with rage, and I think that those were the primary feelings that drove the behavior on that day. This was permissible expert testimony on motive, and there was no error."
Do we generally allow experts to testify as to what motivated a defendant?
I would say that the case law has precedent where that happens. Specifically, I would draw your attention to Johnston, wherein a defendant raised a defense of lack of criminal responsibility, and the Commonwealth's forensic psychiatrist testified that disrespect was a motivating factor in the murders, and this court reviewed that and found that it was not error. It is certainly not.
And it was not error because it came to explain why it was not mental illness?
It was relevant to the analysis of what happened in the murder and his state of mind. It was not testimony on the ultimate issue. It was permissible motive testimony, and it's the same thing that happened here, where she marshaled the evidence and asked what drove. I would also note that the defense attorney, in his cross-examination of Dr. Fife, phrased hypotheticals to the doctor using what drove 5 times. There were objections to his questions, so he rephrased it repeatedly, but in each case he asked the expert in his hypothetical, would this be, what drove? He used the word drove and drive 5 times in his cross-examination.
That was after she said drove or before?
It is after, it was on cross-examination. But in addition to it being permissible expert testimony motive, it is certainly not an opinion on the ultimate issue, and looking at Goddard, I would say that that case strongly stands for the proposition that testimony such as this is permissible. Additionally, there was no objection to the Mutina instruction, and the instruction given was proper. The instruction given was from the model jury instructions, but it was followed with a supplemental instruction that was jointly requested by the Commonwealth and the defendant. And the defendant here is making the same argument that was made in Chappelle. There, this court said that an instruction that omits references to specific timeframes for observations and mentions the potential for successive commitment orders may be better, but it did not hold that that was mandatory. And then a year later in Griffin, this court held that giving the model instruction was not error. In this case, the defendant got the instruction he asked for, and the model instruction clearly states that if the person is still suffering from a mental disease or defect and is still dangerous, he is kept in the mental facility. Implicit in that instruction is the potential for lifelong commitment. Finally, the defendant should not be granted any relief under Section 33E. The defendant in this case committed an intentional brutal murder. He stabbed his partner, Kristen Policiano, over and over in front of their teenage daughter, leaving 33 stab wounds on the victim's body. The victim said, "Stop, I love you," and the defendant said, "You've got to die, you've got to die." The defendant had a fair trial, and the jury found that this was a premeditated murder committed with extreme atrocity or cruelty, and the Commonwealth requests that the conviction be affirmed. If there are no further questions.
If I just go back to Dr. Fife briefly.
Sure.
Did she ever offer an opinion using the actual McCool standard?
Well, she testified that he didn't have bipolar disorder. So on the issue of whether he had a mental disease or defect, her answer was no. So it didn't get into the next 2 prongs. The question before...
So she did offer an opinion that he has no mental disease or defect?
Correct, consistent with the McCool standard. And then obviously with that answer, then you don't get to the next 2 prongs.
Can I ask about the Mutina instruction? Did the defendant actually request that instruction at all?
The defendant did request the Mutina instruction. The court said there was discussion at the charge conference about the Mutina instruction, and the defense attorney actually said they agreed that it would be given, and then the defense attorney, I believe it is 139 of the 920 transcript, says, "I actually like the Commonwealth's supplemental instruction better." So after the requested Mutina instruction, the agreed to supplement was, "I have given you this information so that you are not concerned about the possible consequences of the difficult function you are about to perform. Please put the possible consequences out of your mind when you consider your verdict. You must decide the case solely on the evidence before you in light of the law as I have explained it to you." So it's not the same as the proposed, as the appendix to Chappelle that puts out this court's.
So no one requests the Chappelle instruction?
Correct. Are there no further questions?
Okay.
Thank you.